At the moment, I think civil liberties and individual rights are somewhat on the losing side. Of course, development and all that is absolutely important so far as the country is concerned. But at the same time, it is not possible to forget the fact that we are a democracy, we are a republic. So you file an FIR in 5 different parts of the country. Why? Because the defamation is universal in one sense. So you can file it in any part of the country. So that process, becomes a punishment.
The views of the judge in question also come into it. And that may not necessarily be for malified reasons. It could simply be because some judges believe more in the power of the state, and some judges, like you, believe more in the rights of the individual.
Just because somebody says it is defamatory, is it defamatory?
What is your recommendation? Like, what should be done with all this special law?
I think the courts have to realize, given the history of detention in India, whether it is preventive detention or detention for as an accused of a crime, the law has always been in favor of the citizen. That's why we say bail and not jail. It has always been in favor of the citizen. I'm pretty clear that our fundamental freedoms are not negotiable at all. Okay? So we have to do whatever we can as citizens to ensure that the state does not take away or curtail our fundamental freedoms. All right?
This is the India Story, and I'm your host, Vikram Chandra. And today we are going to be talking about individual rights, civil liberties, freedom, your freedom, the freedom of the individual. And who better to talk about that to than Justice Madan Lokur, who's probably been one of the biggest and the most articulate campaigners for the importance of individual rights and civil liberties, not just in India, but around the world. And that's the reason, Justice Lokur, it's such a pleasure to have you with us. You're now the chairperson of the Internal Justice Council of the United Nations, so therefore pretty much championing this cause all across the world. You've been, of course, former Supreme Court judge, both in India and in Fiji, which, of course, was a very interesting assignment. Not every time that somebody can become a judge of the Supreme Court of another country, that also a beautiful country like Fiji. So I began by saying the importance of individual rights, civil liberties, and freedom. There's often a conflict between that and the power of the state. How do you think that battle is going right now?
Well, at the moment, first of all, thank you for inviting me. At the moment, I think, civil liberties and individual rights are somewhat on the losing side. Of course, development and all that is absolutely important so far as the country is concerned. But at the same time, it is not possible to forget the fact that we are a democracy, we are a republic, and there was a long struggle for freedom, which not only involved in freedom from colonial rule, but freedom from some of the laws that were enacted to keep the colony in place. So really, I think individual rights, personal freedoms are absolutely important. But unfortunately, to some extent, I think they're on the losing side.
Losing side just in India? Is it a trend across the world that this particular debate, and I want to come to some of the history because this is not a new debate. National security, the power of the state, the need and the necessity to be able to govern people through some sort of a social order, the clash between that and individual rights actually goes back centuries, right?
Yes.
It's an old battle.
Yeah, you're absolutely right. You see, it's like this, something like national security, all right? As an individual, what do you know about national security? You don't know what's happening on our borders. So you have to actually trust somebody who says that, listen, I know, okay? And that's the leader of the party in power. And if he says it's a national security issue, unless you have some, good reason to disagree, you have no option but to accept it. So something like national security has been used in the recent past, you know, to incarcerate a large number of people, accuse them of sedition because you are, using seditious language or you're doing something seditious. Therefore, it's a threat to national security, and therefore, you should be behind bars. So, that is something which is happening not only in India, but in a different manner, I think, in some of the other countries as well, where persons who do not agree with government policies, for example, are kept behind bars.
Now, what happens is, in the Indian case, again, as in other cases, it's all very well to say, okay, we believe in the following fundamental rights, but then the caveats are added. So, for example, you have freedom of expression, but you say within reasonable bounds, or you say you are allowed to do what you want, but then they are reasonable bounds. Again, there's theory behind that as to whether it should mean actual harm to something or somewhere else. But is that the loophole through which then state power or excessive state power can creep in? Because what is reasonable to one person may not be reasonable to another. What
Yeah.
is reasonable for one judge may not be reasonable for another judge.
Yeah. Okay, that's a very interesting way of looking at it. One of the first few cases, in fact, I think probably the first case with regard to freedom of speech and expression came up in 1950. All right, in the case of Ramesh Thapar, where his publication Crossroads was banned. Now, the Supreme Court said that, listen, we have freedom of speech, we have freedom of expression, right? And therefore also freedom of the press. So, if you look at it from that point of view, okay, you can say what you want, but can you go beyond, a red line, so to speak? Okay, that's really the question that has to be asked. Now, one of the examples that has been given a long time back in the United States Supreme Court was that can you shout fire in a cinema hall? Now, freedom of speech says yes, you can shout fire, but if you do that in a cinema hall, there's going to be a stampede, and anything can happen. So, really, a reasonable restriction has to be put, and that's where the Constituent Assembly felt that yes, we should have a reasonable restriction, not only in question of freedom of speech, but movement, trade, commerce, and so on.
The issue, sir, comes when you are trying to understand what is a reasonable restriction. Now,
Yeah,
obviously, I think most people would agree that if you're saying, okay, let's break up the country, for example, okay, fine, maybe that's not correct. If you're saying, let's go and attack X community or X person, or you're inciting somebody to murder, or you're inciting acts of terrorism, reasonable restriction obviously should kick in and that should not be permitted. But that's actually being interpreted now by into things like, well, this person said something, I don't like what the person said, it offended me, and I'm going to file an FIR.
yeah, yeah. You see, that's where something like judicial discretion comes in. All right. Also, executive discretion, because what what happens when an FIR is filed? Somebody goes and makes a complaint, and the policeman records the complaint, right, and says that, well, an offense has been committed. Now, if somebody says something very innocuous, all right, and you decide to misinterpret it, the executive decides to misinterpret it and say that, well, there's a hidden meaning behind all this. And if you look at the context, this, that, and the other, the whatever has been said is seditious, for example, or is an incitement to violence through a misrepresentation or a misinterpretation or a misunderstanding of what has actually been said, or you take a phrase out of context.
Or
All
you
right.
could also just broaden that to say that, oh, this is an insult to X community or insult to
Yeah.
Y community,
Yeah.
or it's criminal defamation. So therefore,
Absolutely.
it harms a particular person. You could actually interpret these in just about any manner,
You're
and
right.
it happens.
Yeah.
You
Yeah.
can constantly do it.
Yeah. 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 So the first stage really is when it comes to the executive, which in this case means the police. All right. The police says it's an offense. Is it an offense? That's the first question that the police should say, that, or is it protected by freedom of speech? Okay. Then you have the prosecution. Should the prosecution say that, yeah, just because you as the police have said it, it is an offense, therefore I say it is an offense? The prosecution also has to apply its mind, right? And then comes the judiciary also. Now, so far as the judiciary is concerned, it's I think it's been there for many, many years, many decades, that you have to exercise judicial discretion in a judicious manner. You know, not that, because I think it's in a particular, or I look at something in a particular light, therefore, it's an offense or it's not an offense. But what does the law say? Okay. So you have these various stages. Now, when we talk about, our civil liberties, our fundamental rights being somewhat on the losing side, um, why is that? That's because the police is lodging FIRs against people even though they have not violated any law.
Right.
All right. The police thinks, oh, I think, or somebody says and goes to the police and says that, I think it's going to cause a problem. Right. So you
And
then, yeah.
And then there are 2 or 3 other aspects to this which I would like to discuss with you. Why does the problem become worse? Specifically in India, one of the reasons why the problem becomes much worse is once somebody has gone and filed an FIR, and then typically what will happen is they'll file an FIR in 4 or 5 different states, right? And then you're running from one place to the other. This is where the delay in the judicial system is really what starts to cause the problem. It's one thing to say that somebody's filed an FIR and I have to just go there and give a statement, and then, if they can't prove that I've done something wrong, it'll be buried within a week, 2 weeks, 3 weeks. Once the FIR has been lodged, it could take 8 years. It could take 10 years. It could take 30 years before that thing is finally buried. So you're facing the constant prospect of process being the punishment, of harassment therefore ensuing. And that's what causes the chilling effect on your freedom of speech or freedom of
Absolutely.
expression.
Absolutely. But, it's not a new thing.
Yeah.
Okay.
And then none of this is new, by the way.
Yeah,
This is, you can argue shades of, when it's been happening more or less.
Yes.
But is this the crux, one of the cruxes of the problem? So
Yeah,
if you
it
can't
is.
speed up the judicial process, you'll continue to have a chilling effect.
Yeah. You see, that's one aspect of it. But let me go back maybe about 10, 15, 20 years. We have a very, very large number of cases relating to bouncing of checks. Okay. So if somebody gives you a check and it bounces, it's a criminal offense under the Negotiable Instruments Act. Now, one of the questions that arose was, where is the jurisdiction? So a lot of people at one point of time had opened bank accounts in Sikkim, for example. Okay. And they would, deposit the check over there. And if it bounced, file a criminal case in Sikkim. Now, for somebody from, say, Maharashtra, or even somebody from Delhi, to go to Sikkim to defend the case is not easy. All right. So these are tactics which are sometimes used to harass a person. So when you talk about criminal defamation, okay, you file a criminal defamation, and it has happened actually to a person in Mumbai. A criminal defamation case was filed against him in Tripura. Okay, now you can go to Tripura. I mean, it's not a foreign country or something, but you have to go to Calcutta. Then from Calcutta, you have to go to Tripura, and you have to keep going there for the case. It's not only once, but several times. So it becomes a harassment. That's one aspect. The second aspect is filing the same kind of an FIR in different parts of the country. So you file an FIR in 5 different parts of the country. Why? Because the defamation is universal in one sense. So you can file it in any part of the country. So that process, becomes a punishment.
Yeah.
Where the accused person has to go to different parts of the country to defend what he or she had said. So how do you tackle that? Okay. Now, you can tackle that by 2 different ways. One is by settling what the law is and saying that, well, decide on one place which has jurisdiction.
Right.
It could be the place where the accused resides, or it could be the place where somebody has been defamed resides, and that's it.
Compounding the issue of what you had said, that cases can be filed and then the process becomes the punishment, is the political aspect of it, right? So therefore, when you say, is this if you hear about it, you read about it, that somebody has gone and filed a case against somebody else, is it good or is it bad? You have to ask the random person on social media. The answer will quite often be, it depends. If you're a left-wing supporter and it's a right-wing government, it depends on who it is. If you're a BJP supporter and it's the BJP government which has done it, which said it's absolutely fine. If you're a BJP supporter and the Congress government has done it, or the Trinamool Congress has done it, oh, it's bad. And vice versa. If you're a Congress supporter or a Trinamool supporter or a DMK supporter and you've done it, then that's absolutely fine. So this is part of the issue, that there's no consistent belief that we seem to have that harassment is bad, frivolous FIRs are bad, cases are bad. It becomes a question of who did it to whom, and then we will tell you whether it is good or bad.
Yeah, yeah, yeah. But that's where the judiciary comes in. I mean, people can have their own opinion. That yes, it is defamatory. No, it is not defamatory. What has happened is good. What has not happened is better. But that's where the judiciary comes in. And that's where discretion of the judiciary has to be exercised, like I said, judiciously. Okay, just because somebody says it is defamatory, is it defamatory?
The issue here is that A, it takes a lot of time, so the process of the punishment, and B, and perhaps more seriously, the minute you're leaving things to discretion, then sometimes the views of the judge in question also come into it. And that may not necessarily be for malified reasons. It could simply be because some judges believe more in the power of the state, and some judges, like you, believe more in the rights of the individual.
You see, it's like this. There are two parts, to what you are saying. One is the time factor. Okay, you're right. Cases can take any amount of time. That's not good. Okay, so the time factor itself is, in a sense, a punishment. If you're going to be told that, listen, you're going to get justice, but you'll get it after 10 years or after 5 years, things can change in that 10 or 5 years. So that's one aspect where I entirely agree with you that the process becomes the punishment, not only because of the process or the procedures, but also because of time. The second aspect, is about, judicial discretion. One judge thinks that, yes, this is the way it should be done. Another judge thinks this is not the way it should be done. There has to be certainty. There is no doubt about it. It's not that, because a judge thinks that it should, it's a crime. The other judge says, no, I don't think it's a crime. On not the decision not being based on the material on record, or not being based on precedents laid down by the courts or an understanding of the law, then you're running into a problem.
But
Right?
it doesn't necessarily. So if you look at practically how it happens, for
Yeah.
example, and this can happen all the way up to the Supreme Court.
Yes.
Even at the Supreme Court, the same issue, the same matter, let's say it's a bail question in a, I don't know, PMLA matter or a UAPA matter. It goes to a particular bench. That bench will say these are heinous offenses and therefore no bail should be granted. It goes to another bench. That bench will say these are matters of individual liberties and fundamental rights and therefore bail should be granted. So the fact of the matter is that it's a balance. These are not determinate black and white matters. Should it be determinate and black and white and in some way codified so that it is not left to judicial discretion?
It's very difficult. It's very difficult to codify discretion, right? But I keep saying this. Look at the material before you. Look at the evidence before you.
But
And-
every judge would look at the material differently.
Yeah, but then you can't help it. I mean, there has been a case, let me tell you, there has been a case where 3 judges heard a case. One judge acquitted the person. It was a murder case. He said that, no, he's not guilty of murder. A second judge said, yes, he's guilty of murder, and should be given life imprisonment. A third judge said that yes, he's guilty of murder and should be given death. So three judges, absolutely reasonable persons, came to different conclusions on the same set of facts. Okay, so that's part of it. I mean, you can't avoid that.
So that actually comes to bear on different interpretation of the facts by the time you are through with the trial, by
Right.
which all the facts are being done. But if you look at it from a practical point of view, when it comes to how individual liberties and civil liberties can be eroded, it happens at the very outset on something like bail. Now, we
Yeah.
keep hearing bail is the norm and, jail is the exception. It's not practiced on the ground.
Yeah.
Different courts will interpret it differently. You will have the Supreme Court passing direct instructions saying that you must follow this dictum. Sessions courts will not follow it. And different judges will take a different prima facie, look at when somebody comes in front of them for bail. This is the fundamental aspect. This is the very core of individual liberties, the question of bail.
Yeah.
We can't agree on how it should happen.
Yeah, you're absolutely right. But there are two things. One is interpretation of facts. The other is interpretation of the law. Okay, I might look at a certain set of facts differently from the way you look at that set of facts. But what is the law? Does the law preclude you from granting bail? Does the law preclude me from granting bail? So on the legal principles, there should not be any confusion, or there should not be any divergence of opinion, right? Unless it is some constitutional issue or something where there can perhaps be a different way of looking at the law.
But Justice Lokur, I know how upset you've got about this through your entire career. And frankly, as a journalist, I've been looking at the state of under trials in prisons for my entire career. And I've said there's something wrong with the system where a lot of the people who are incarcerated do not need to be incarcerated.
Yeah,
they should have been out on
absolutely.
bail a long time back.
I agree.
They don't have lawyers. The rich will still be able to find lawyers and find ways of getting themselves heard. A lot of the people just can't afford it, and they spend years in prison as under trials when they may not have needed to. And at the end of the entire process, they are acquitted and no one can give them back those years of their lives.
Yes.
So how do we fix this question of bail, right? Do we need to codify it? Do we need to have does the Supreme Court and a bunch of judges need to sit and say, look, these are the principles, please follow them blindly. Don't leave it to discretion then.
Yeah. You see, it's like this. Let's take bail, all right? Bail is discretionary in the sense that on the given set of facts, none of which are proved, because the investigation is still going on, or, charge sheet has been filed and so on. On a given set of facts, should a person be granted bail or should a person not be granted bail? Okay. Now, the principles are very well settled. Is that person likely to tamper with the evidence? Is that person likely to influence the witnesses? Is that person likely to, make himself unavailable for the trial? Okay. These are, the broad principles. Now, if there is no material, and let me tell you, it happens in very many cases, there is no material to suggest that this person is going to tamper with the evidence. The police says, we believe he's going to tamper with the evidence. So therefore, he should not be granted bail. The judge should ask, what is the material for you to come to that conclusion? That question is not asked. Normally not asked. Now, the police say that, we think he's going to influence the witnesses. What is the material for coming to that conclusion? If there is no material, just because you say he's going to influence the witnesses, or just because you say that he's going to tamper with the evidence, the judge should say, listen, I'm not prepared to accept it.
So should you have so that's what I'm talking about, codification.
Yeah.
And seeing as the Supreme Court has been talking about the importance of this, should that judicial discretion then be sort of circumscribed to some extent to say, is this person a known criminal? could this person actually harm, witnesses because this person has a history of doing this? I mean, a charge sheeter, in other words, a habitual criminal. Maybe you should be more careful with that. A person who's asking for bail in a rape case, who's actually committed, multiple offenses in the past. Maybe you could say, other than those cases, first-time offender, somebody coming to you without any particular reason to believe X, Y, Z will happen, the presumption should be bail. Is that what individual rights and civil liberties should be saying?
Yeah, you're right. You see, why do you want to put a person in jail? Okay, there has to be a reason. It's not because I want that person to be in jail, therefore he should be in jail. There has to be a reason for that. Okay.
In political matters, quite often that is the reason, right? I want this person to be in
Okay.
jail.
Yeah.
That's it.
Okay, yeah. But then that's where the judiciary has a very important role to play. Okay, that's why, we talk about the independence of the judiciary. All right. Just because you say something, as a judge, I don't have to believe it unless you give me some evidence. And evidence which I can rely upon, not evidence that, I'm a great person, so therefore you must listen to me. No, that's not evidence. So these are things, which have to be looked into by the judiciary. And once they look into that, the problem of bail, for example, will be over. You have a first-time offender, no evidence that he will, influence the witnesses, no evidence that he will run away, no evidence that he will tamper with the evidence. Give him bail.
Right.
Right. Now, you have, in India, it is said about 70 or 75% of the people who are in jail today are persons who are under trial prisoners, which means they have not been convicted. Many of them would be first-time offenders. All right. You have the Probation of Offenders Act. How often is that used in the case of first-time offenders? You have provisions in the law for plea bargaining. How often is that used? All right.
Possibility of house arrest if you really want to find other ways.
Yeah. I mean, there's so many ways which need to be explored, but which are not being explored. So you just say, all right, let this guy be in jail. We'll see at some point of time.
Some of the systems that are followed in other countries, trying to find solutions for the future, how to fix this problem, they do things like bail bonds and others, for example. In India, I guess that will then make it a bigger problem, as it does, for example, in the United States, because the rich can afford it, the poor can't.
Yeah, but then I think there are enough judgments to say that, listen, the bail bond has to be reasonable. A person who's unemployed, for example, and you tell him you give a bond of 1 lakh rupees, there's no way he can do it. There are instances, by the way, where a person has committed an offense and he's in jail in some state other than his home state. And, the judge says that you bring 2 sureties of 10,000 rupees or 15,000 rupees or something. Now, he's not from that state, He may have committed an offense over there while he was there for maybe 10 days or 15 days or something. Where is he going to get a surety from?
Right.
So somebody who can say that, listen, I trust this guy. I mean, you met him 15 days ago. How can you trust him? So these are things which need to be looked at. If we want to bring about judicial reform, not only, across the board, but also in matters of civil liberties, also in matters of fundamental freedoms, I think we need to sit down and discuss it.
There are, of course, where the problem becomes, I think, even more acute is when it comes to the special laws.
Yeah.
You've often spoken out against laws like AFSPA, for example, or UAPA, or PMLA, or the Drugs Act. There are certain acts and statutes which almost suspend the way justice should be done, because they say this is a special case, right? So therefore, the norm becomes jail, not bail. The norm becomes, twin conditions in PMLA. The norm becomes, there are various confounding principles that then come into it. What is your take on all of these special laws?
Yeah, you see, these special laws, I think the courts have to give a somewhat more liberal interpretation to them. The law does say, that the burden is on the accused person after a point of time. Um, if the state, makes out a case, then the burden is on the accused. It's a very, very, very difficult burden to discharge. You know, it's very difficult for a person to prove the negative, to say that I'm not guilty, or that I have not committed the crime. Okay, but I think the courts have to appreciate that the burden is very heavy on the accused person. And again, come back to the initial thing, that have you proved, has the prosecution proved to the satisfaction of the court that there is an offense that has been committed?
So, if you look at these special laws, they exist for a particular reason, right?
Yeah,
These are considered those cases where, when it comes to that balance we've been talking about, national security and the common good or the public good on the one hand, and individual freedom on the other, there's a perception that, oh, this is a matter of terrorism or whatever, organized crime, and therefore national security should come first and not the right of the individual. But obviously, the scope for misuse is extensive and has been ever since these laws. Again, these laws are nothing new. You can go all the way back to the emergency in MISA, and there's TADA, and there's UAPA, and there's other such things. They can be misused, and some people will say the minute you have a law which gives the state the potential to misuse it, it will get misused. Actually, any laws like that, you can extend that.
Yeah. Okay, now that you mentioned MISA, all right, let's go back to the days of the emergency. MISA is maintenance of internal security. All right. Now, that's a preventive detention law. So you may not have committed an offense, but the prognosis is that you will commit an offense. So to prevent you from committing that offense, you are being detained under MISA. And what is the nature of the offense of which there is a prognosis? Internal security. Okay. The courts, the high courts, persons were detained under MISA, and they said the law of preventive detention is very clear. Under the Constitution, you have to give the person the right to represent himself, for which he must know why he has been detained. Okay. And the right to represent himself doesn't mean that, okay, we'll give you time to represent yourself, after 2 months, after 3 months. It has to be immediate. Otherwise, the detention becomes illegal. And even during the emergency, many of the high courts, I think 10 or 11 high courts, released persons who were kept under MISA. Why? Because the procedural law was not being followed. Even recently, under the Conservation of Foreign Exchange and Smuggling Activities Act, National Security Act, persons have been released. Why? Because the procedure has not been followed. You give them the grounds of arrest in a language which they do not understand. How can that person represent?
So, what is the way forward on special laws, right?
Yeah.
And like, if you look at it, the Supreme Court, which, for example, came up and said, well, all of these rights that have been given to the state under a PMLA, for example, or UAPA are okay in PMLA. The Supreme Court specifically said that. Later, it says, why are these provisions being misused? Other benches come up and say that. So, even at the judiciary, it's not very clear what they think the path forward is. What is your recommendation? Like, what should be done with all the special laws?
Yeah, I think, the courts have to realize, given the history of, detention in India, whether it is preventive detention or detention for, as an accused of a crime, the law has always been in favor of the citizen. That's why we say bail and not jail. It has always been in favor of the citizen. Okay.
That's the constitutional provision, right? That in the battle between the two, the rights of the citizen should be treated with priority.
With priority. Yeah. Why? Because the individual cannot protect himself or herself from state excesses but the state can protect itself from the excesses of an individual. All right. So if the state uses excessive is uses excessive power or excessive authority, how is the citizen going to protect himself or herself? It can only be done through the courts.
That's a really interesting way of looking at it. So you're saying the primacy of fundamental rights and the primacy of individual freedoms comes from that,
Yeah,
that the
yeah,
individual is fundamentally powerless against the state,
correct.
and therefore you've got to ensure that the individual is protected from excessive state power.
Yeah, absolutely, absolutely. The state can protect itself, and it does in the sense of, putting a person behind bars.
All right. If you come to the way all of this is now panning out in India, I mean, there's been a lot of discussion, of course, on recent Freedom House rankings or VDEM rankings, which says, oh, India is not as free a country as it once was. Now, of course, there's a lot of controversy over it and whether those are fair, assessments or not. The government will say those are not fair assessments. But if you look at the methodology and you look at the way they rank it, nobody says that India is not a democracy or is not free when it comes to elections. Everyone seems to agree that India has completely free and fair elections and things are working fine. These agencies do too. India gets high scores on that. Where India gets lower scores is in civil liberties, is in individual rights, freedom of the press, issues like that. Do you think that's a fair assessment of the situation?
Yeah, you see, frankly, I don't know what is the kind of methodology that is being adopted by VDEM and some of these organizations.
Yeah, that methodology has been questioned a lot in
Yeah,
recent
yeah.
times. Yeah.
But I think if it is, if it's across the board, accepted by so many other countries, perhaps there is some sense to it. But I would also go and a step further and say that if you say that the methodology is wrong, what according to you is the correct methodology to be adopted? And if you adopt that correct methodology, what is it? What are your conclusions? So, supposing VDEM says, that in a score of 100, for example, India gets only 60 in terms of personal freedoms. And you say, well, I don't agree with their methodology. I don't agree with their assessment. According to me, this is wrong with their methodology, and this should be the correct methodology. And if this correct methodology, which I am advocating,
Mm.
is accepted, we'll probably get 70. Fine, But just to say that, listen, you're wrong and I don't accept it, doesn't take us anywhere, because it's a matter of record.
But and it's certainly worth sort of looking at it and seeing how things can be made better. Because if brand India suffers sometimes in recent times, it's because of issues like this, right? Because nobody can doubt that India, being the largest democracy in the world, has been one of our major aspects of the India story, and brand India has been a very important part of it. So if there's a perception, right or wrong, that in some way freedoms are under question, it's important to try and address the root causes and also then the perception.
Yeah, yeah, yeah. Yeah, you see, we living in India know what's happening.
When I come back to the question what you said about the various aspects of liberty and civil liberties. Obviously, the freedom of the press is a very important part on it. In that and in other areas, one of the things that is starting to happen is that if the job of the press is to speak truth to power, and that could be your local daroga at the at your district level, your local DMA or daroga, it could be the state government, it could be the central government, it could be whoever. If the job of a journalist is to speak truth to power, that's where the state's power, which you were talking about, is always more. That state will have more danda than the journalist will. Somewhere in that battle is the balance shifting more to the state and away from the journalist.
Yeah, I think it is. Yeah. I mean, okay. I watch television once in a while. Okay. Now, some of the discussions that take place, or some of the news reports that come, are of no consequence at all. I mean, it's just to fill up time, kind of thing.
One of the issues that, of course, is happening is that whether it's at the daroga level or the state level or the central level or other levels, new ways are being found to exercise state power. I mean, people don't necessarily go after reporters to say, you said this, so I'm going to come and do it. They find other creative things, right? Organizations will find, cases being put against them for whatever, you didn't pay your duty, you tax fraud, XYZ. Those things will happen.
Yeah, yeah. Yeah, I suppose so.
And
But
that's
then,
not just true in India, that's around the world.
yeah,
People have found other ways now
yeah,
of
yeah, yeah,
muscling.
yeah, absolutely. Yeah. That's because the state wants to assert its authority. All right. So if the law permits you to do something, by all means, use that power. If the law doesn't permit you to do something, misinterpret the law and still exercise that power. I think this is what is happening, you know. And again, then we come back to the same situation that assuming this happens, and it is happening in some places, what is the remedy available to the state, to the citizen, or to the organization, or to the journalist? The only remedy available is to go to the courts. And if you go to the courts and it's going to take you years to get justice, you might as well succumb to the pressure.
Yeah, and I'm sure that happens. Right. Let's now look ahead a little bit. Right. I want to try and get the purpose of this entire show is to try and find ways of solving the problem so that the India story can play itself out in the correct manner. If you believe, and you seem to be saying that you have to continue to defend the rights of the individual and civil liberties, because the individuals fundamentally are the unit of society and they're relatively powerless against state power. What would be the 3 or 4 suggestions that you think we can practically put into place in the next 4 or 5 years?
Well, I think so far as the courts are concerned, the one thing that they have to do is to sit down, have a brainstorming session, and decide where are we going wrong. You know, um, are we going wrong? And if yes, where are we going wrong? That's one aspect of it. The second aspect of it, which started off with a bit of a bang, maybe about 10, 15 years ago, was judicial education. Okay, where every state has a judicial academy where judges are trained or given education on what the law is. Have some kind of an audit, performance audit or social audit. Are they doing their job? Why is it that we are getting some judgments which just cannot be supported? After all, it is those judges who have perhaps gone through a course in judicial education. I don't know, but how is it that you're getting some of these judgments? So you have to look at the whole thing as a sort of a package deal.
Right. But just last question, when people are asking you, where is India going to be 2035, 40 years, we look ahead. Would you believe that fundamentally freedom and the rights of the individual freedom, individual liberty is part of the basic structure of the Constitution, something that is not going to go away, and that India will fundamentally be a free country and will remain a free country? And by a free country, I mean a country where the individual has full freedom.
Yes. You see, I think I'm pretty clear that our fundamental freedoms are not negotiable at all. Okay. So we have to do whatever we can as citizens to ensure that the state does not take away or curtail our fundamental freedoms. All right. We also have to ensure that the people that we elect to the legislatures are persons who are going to protect individual liberties, not use their authority or their power for reasons other than protecting the constitution, protecting the basic structure of the constitution, and protecting individual liberty.
When you said that individual freedom is non-negotiable, um, Is that a view, or is that also something that you think is enshrined in our constitution and in the basic structure of the constitution? Freedom of the individual is non-negotiable. You can argue about the checks and balances.
Yeah.
You can argue about what's reasonable and not reasonable, but fundamentally, individual freedom is non-negotiable according to the constitution.
Yeah, absolutely. I mean, the fundamental rights chapter, in my view, is a part of the basic structure of, or a basic feature of the Constitution.
So individual rights, individual freedoms, freedom of speech, all of those things
Yeah,
are non-negotiable also.
Absolutely.
Well, before we go, Justice Lokur, I just wanted to ask you your sense of how important these issues are for the Indian citizen, for the individual. Do you think the freedoms that they have got are really important to the 1.4 billion people in India?
Oh yes. And history has taught us that. Freedoms were curtailed, if not emasculated, during the emergency. And look what happened immediately after that. Right? So, freedoms are definitely important.
And perhaps one of the reasons why it's so important for the individual is that for that, literally that Aam Aadmi out in the rural, in some rural part of India, you were talking about the powerless individual against the state. For that person, it's even more critical because he's a farmer, he's somebody running a chai ki dukaan on the streets of Bihar somewhere. And for him, the potential power of the daroga or the whoever else represents the state for him can be a really impressive phenomenon. That person can be picked up tomorrow, thrown into prison, beaten up with no recourse. That's why freedom and civil liberties are so important for every Indian.
Yeah, absolutely. Zamindars, for example, okay, they could also control, persons. Bonded labor. Ask a person who's a bonded laborer that, is freedom important for you? And there's no doubt that he will say yes.
And that eventually is perhaps the greatest reason for hope, right? That freedom, liberty, civil rights will always persist in India, not just because the judiciary wants it to, or the government wants it to, or the media wants it to.
The people want it.
Freedom will persist because the people of India want to be in a free country. And they want to be free.
Absolutely.
Justice Lokur, such a pleasure talking to you.
Thank you.
This is Vikram Chandra. Thanks for watching the India Story podcast. For plenty of other exciting conversations and podcasts, make sure to log on to Hook.